Hi guys, my name is Kyle Lindgren. I'll be going over the competence for execution in the waiver of appeals. Start off, we want to talk about the prohibition against executing incompetent individuals, which was brought forth in the Supreme Court case Ford v. Wainwright, which prohibits executing someone who is deemed insane, which is in line with the Eighth Amendment against cruel and unusual punishment. The definition for competence to be executed suggested by Justice Powell, requires that awareness of the punishment and understanding of why it is being imposed. States like Florida adopted standards requiring that a defendant understands the nature and effect of the penalty, death penalty before the execution. Later on, this was found unconstitutional for the reasons following this. Um, Although there is no constitutional right um, to competence in collateral proceedings, there are calls for such requirement to ensure fair resolution of claims. Some requirement for decision making, competent for competence, uh, as said by the American Bar Association, stipulates that individuals must be able to rationally choose to forego or terminate post-conviction proceedings, especially in cases of mental disorder. The Supreme Court's stance on this, we see in Panetti v. Quarterman. The court ruled that the understanding the reason for execution must relate to communal understanding and not just the personal belief of um, either side. There are some procedures for determining competence, as declared in the Ford v. Wainwright, indicating that prisoners must have the opportunity to be heard and to be able to challenge competence evaluations, emphasizing a need for a fair hearing process. Um, some recommendations for independent evaluations set by the ABA advocate for indigent prisoners to have access to independent competence evaluations with legal representation during hearings. If you want to look more into the 4V framework, that'll be in the comment below my video. Some evaluation issues and some how we go about evaluating people that are going to be executed. We have two tools that are used mainly. The eBirth's competency to be executed rating instrument, which is 12 items, 8 functional legal abilities, and 4 clinical inquiries to help understand more about the situation for the inmate. The second one is the interview checklist for evaluations, which is again kind of the same thing. If you want to check that out, it'll be on the next slide. There are some ethical concerns surrounding the mental health evaluations of death row inmates. Some professionals believe that psychologists should limit their participation in these evaluations due to biases influencing their judgment, whether they're too close or it hits home too much. Uh, Also, evaluate the location of the evaluation can affect um, how the answers come about, whether it's the questions from the assessor or the answers from the inmate. So an unbiased evaluation would be the would most likely happen in a neutral site. Um, there are some limitations of the assessment tools. They don't fully quantify an inmate's competency. Some assessments provide qualitative judgments rather than numerical scores, which may not fully capture the inmate's mental state. Um, to focus on the current functioning, evaluators should concentrate on the inmate's current mental state rather than their history of when, either during the case or at the time of the crime. Interviews are also a great way to um, understand what the inmate is going through, what they're like, not just questions, just basically just talking to the person. Um, some waiver of appeals is in capital cases, defendants may waive their rights to post-conviction hearings against their counsel's advice, raising issues about the rationality of their decision. Many defendants who volunteer for execution might suffer from serious mental disorders, thus impacting their motivation and decision making, thus also complicating the evaluation of their competence and voluntariness. The need for understanding and communication helps assess the inmate's ability to communicate with their lawyer, um, to make sure that the best decision is being made for the inmate, whether they're going to go and do by themselves or they're going to have their lawyer with them. There's going to be the table if you guys want to check it out. Some treatment issues. We're going to be talking about the case, mostly the Perry v. Louisiana, where the court found Perry incompetent to be executed without medication. Thus, he was ordered involuntary medication to ensure competence, later contested in the Supreme Court. Supreme Court's intervention vacated the lower court's order for reconsideration, which allowed forcible medication for dangerous prisoners deemed medically appropriate, whether they are too dangerous or, um, yeah. Uh, Louisiana's Supreme Court's decision ended up being that the court concluded that involuntary medication for execution is impermissible, that it is being labeled as cruel and unusual punishment, going back to like the Eighth Amendment, if there's the medical treatment was not met. Independent reasons against forcible medication. In Louisiana court cited that two main reasons against the practice. First, it argued that it fails to contribute to the social goals of capital punishment, and second, is prone to arbitrary administration. In a separate case, we see the Cell versus United States. The Supreme Court established that defendants have a right to refuse the medication. This only applies if they are non-dangerous, competent in decision making, and they're not facing serious charges. Um, Involuntary medication guidelines may be permitted if medically appropriate and serves the state interest. It is only to help treat the person and not solely just for the execution. Some ethical dilemmas for the healthcare providers, that it helps the National Medical Association advocates for providing necessary treatment regardless of the legal status. Some concerns about the treatment decision making. Ethical concerns arise when prisoners cannot express their desire for a treatment. My discussion question is, do you think there should be crimes that are so evil that they should be declared for execution despite their competency? Thank you for listening.